The truth will reveal that this is not just another act of violent racism. Greg McMichael did not commit murder. Greg McMichael is not a party to the crime of murder. This is not some sort of hate crime fueled by racism. It is and remains the case, however, that a young African-American man has lost his life to violence. That is tragic.
And so let me bring in my guest right now real quick. Imran Ansari out of New York at Ayadel Law, 88, the Kings County DA's office, prosecuted hundreds of cases and is a TV legal analyst for the Law&Crime Report. And Gigi Rodriguez out of Miami, Florida, criminal defense, and daughter of a criminal defense lawyer. So like me, Gigi Gonzalez, you have a father, like I had a father who was a lawyer. So welcome to the show. I know it's in your DNA, Gigi.
Thank you very much. I'm very happy to be here.
Yeah, so Gigi, let me go to you. What about the developments that are going on in this case? I mean, it's obviously going to be disputed. What's happening right now is they're making a motion for bond. They want to have the two defendants, the father and the son, released from the jail. What do you think about the likelihood of the success or the merits of that particular argument?
I don't think that the defense is going to be successful, quite frankly. The defendants are charged with felony murder, malice murder, false imprisonment, and a host of other charges. Those are very serious charges, and they're not usually bondable offenses. The defendants are going to have to show that the state does not have the evidence to support these charges, which I know that they asked for an evidentiary hearing. That will be determined. The state will bring in their evidence, and the judge will make a determination as to whether or not the state does have enough evidence to hold these charges to them. And then the defendants, if that doesn't succeed, if it does succeed, then maybe they'll have a shot at getting a bond if they can demonstrate that they're not a risk of flight and they're not a danger to the community and that they can ensure their presence in court. But if the state is able to prove that they've got the evidence to support these charges, the likelihood of them receiving bond is very slim.
Imran, let me go to you real quick about something that I found interesting in this case. In the beginning, remember, these defendants weren't arrested until months later. Another prosecutor reviewing this case wrote an email that news media has recovered that indicated that the defendants were legally carrying the guns, that they were pursuing a burglary suspect, and Georgia law permits a private person to arrest an offender for an offense committed in their presence or within their immediate knowledge. It seems like, you have to remember that one of the defendants in this case, the father, is a retired law enforcement officer. There's also further indications that the district attorney at some point in time indicated that they saw the victim in this case actually in an empty lot, quote unquote, potentially burglarizing it. So that is the reason why the charges weren't brought in the beginning. Do you expect that the defense is going to bring that out, or can they bring that out? And that they can say that the only reason that this case was charged is because there was the court of public opinion and all of the uproar it caused? Is that going to be admissible at trial?
Well, if I was the prosecution, I would be looking to keep that out. I would be filing a motion in limine prior to the start of the trial, and I would not allow the defense to present that sort of evidence if they put on a defense. However, you have to look at the set of facts here, and although there are facts that we can expect the defense to go to that backstory on behalf of their clients to say that they saw this individual in a residence and they were using their ability under Georgia law to address the situation. However, I think the prosecution is going to be pointing to the fact that this individual was now away from that residential that house. This individual was walking down the street or jogging down the street, and there was a pursuit by these defendants when they can easily have called 911. They could have called the police if they thought something suspicious was going on, if there was even something suspicious going on. But rather, these individuals took justice in their own hands. And whether that was allowable under Georgia law under the circumstances, because this person was on the street. He was not in a residential house. It wasn't someone confronting someone in their house. These individuals pursued this young man, and I think that's what the prosecution is going to be hitting home.
Gigi, there is some information here that a 911 call was in fact placed indicating that they believe that there was some nefarious activity. And we do know that there was a video that they are claiming shows that he was at that location. He wasn't jogging, which is what the victim's family and their defense is and that they had this 911 call. They have him at this location, which kind of supports, at least this is what I believe the defense will say, supports that the defendants pursued him because they believed that there were a rash of burglaries going on in that community, and he was found there. And they, in fact, called 911 and asked for police assistance, but didn't want him to get away. It's going to be an argument, isn't it?
It's definitely an argument. And let's just say that all is what happened. The Georgia law does not allow them to execute people that they suspect to burglarize properties. They allow them to arrest them and pursue them. And if they can get the police over there in time, great. But the law does not give the defendants license to execute Ahmaud Arbery. Why didn't they call the cops and pursue and watch where Ahmaud Arbery was going, follow him in his truck, what have you? But to execute them and to get out of their truck and to stop them, to stop Ahmaud Arbery with a gun and fight him down, I don't think was an appropriate escalation of the situation.
Okay, just want to get your guys' real quick take on this and put your defense lawyer hats on when you're looking at it. That video shows, and the argument by the father that was made to the police was that they got out of the vehicle and his son got punched in the face and during a scuffle over grabbing the weapon, which is completely understandable why the victim would have done that. But during that scuffle, the shots went off. So there could be an argument, and that was something that the previous prosecutor that I mentioned said, that there could be a self-defense in this case. Are these all arguments, Imran, you're going to be making or not? As a defense lawyer, where are you going with it? Put it together for me.
No, absolutely. I would definitely be putting forth a justification defense in this case, saying that there was a perception and a real perceived threat that deadly force would be turned and used against my client. And that's why certain actions were taken in order to confront that threat, and it was appropriate under the law of justification and self-defense. But that's definitely a defense I would be putting forth for my client. I would really be putting forth any cognizable defense under the law in this case, because we have a public perception that we're dealing with there. We have the prosecutor's office just taken, as you referenced that letter, two different positions. So you have to take every defense available under the circumstances here, using the video and spinning it in favor of your client as a defense attorney. And of course, the justification defense would be a major defense that we would be put forth, that this individual was going for the gun and there was no other choice but other to take that deadly force to counter perceived deadly force.
Well, you know this is going to go to trial because it's a life without parole case, and you know the Law&Crime will head on gavel to gavel. Anyway, the bond hearing was today. Let's listen to some audio that we have and video that we have with respect to the positions of the parties.
If the state is permitted to go into what they have proposed to go into on their case in chief this morning's bond hearing, we do not intend to offer this evidence that we believe falls under 404B, but also falls under admissible evidence of mental illness, unless the state attempts to use the facts of the case and to try to characterize those facts of the case in a way that speaks to the bond factors. So we have preemptively informed the state as well as the court of the evidence that we would intend to go into should the court allow the state to use the preliminary hearing transcript to establish certain facts. For example, previously the court allowed the state to offer evidence of the facts of the case to deal with the issue of seriousness of the offense and the possible consequences of conviction as a way to look at the possibility of flight. And so the state was able to then characterize evidence and facts and argue that they fit under flight and that this offense was so serious that there was a risk of flight. And the court adopted that argument into its order ultimately, and seriousness of offense is something that the court can consider. However, we would intend, if the court allows the state to get into that, to show why we believe this case is not only defensible, but winnable on the issues that would be allowed to come in at trial that rebuts the facts that the state seeks to enter.
So that's the bond hearing in progress. There's an expectation that at least 5 witnesses are going to be called during that. Gigi, I kind of think he's making the legal argument that I was kind of referring to before with respect to the likelihood of success at trial, and basically saying we believe we can win this case based on the facts. What do you think? That certainly is a good argument to make at a bond hearing. How persuasive do you think it is based upon, again, I'm putting your defense lawyer hat on, everything we've been talking about in terms of getting bailed out? And again, presumed innocent, and they're very serious charges, there's no question about it. But are these individuals who have otherwise been law-abiding citizens, one of them who has in fact been a police officer and a detective from the district attorney's office, really a flight risk here?
I thought that from what I heard, the defense attorney made a really great argument and really held the prosecutor to the fire and made them is going to make them streamline their case. Whatever facts that the state is going to bring up, the defense alleges that they have facts that rebut what the state contends. And I think that in itself is very persuasive. I would like to see what the defense brings to assert their position. But I think so far they've made a pretty good point and standing.
Yeah, Imran, what do you think about the idea with respect to at least a bond hearing? And keep in mind, these individuals weren't arrested until months later and they never fled. I'm sure that'll be another argument that's going to be raised by the defense.
Yeah, Bob, you got to remember what what the standard the court is looking at here, and what they are applying when considering a bail application like this. And it really is first and foremost risk of flight. Is this defendant a risk of flight? If this defendant is released on their own recognizance or given bail, I should say, will they flee the jurisdiction? Will they appear for the next court date? And that is really the first and foremost consideration that courts across this country, whether it be state or federal, are really considering on whether to grant bail or bond. Yes, seriousness of the crime is a consideration. On a violent crime, often the court will take that into consideration quite heavily. But as you say, these individuals, they knew they were being investigated. They knew that this shooting was under the microscope, if you will, in the prosecutor's office and by law enforcement, and they didn't flee. So the argument, I think it's a relatively strong argument for the defense that if they are granted bail or bond, they're not going to be fleeing the jurisdiction. They're going to appear for their next court date. They've invested in private counsel. And although the charges that they are facing are serious, they do have a defense which arguably has merit. And that is also something that the court will consider in whether to grant bail or bond or whether to keep a defendant behind bars.
All right, excellently put, Imran. That is going to be the argument. We're interested in what you think about this. Go to Facebook. Let us know your thoughts. I'd love to make comments to any questions that you guys ask. We're going to take a quick break, but we're going to come back on the other side with Michael Avenatti, still in the news. We'll be right back.
All right, welcome back. Michael Avenatti back in the news. An April 2021 trial date being set for allegations that he actually stole and embezzled money from Stormy Daniels, who wrote the book, or memoir, Full Disclosure, as you may recall. Basically, they're indicating that there was fraud done, money taken to buy a Ferrari and to take trips and to buy clothes and dry cleaning bills. Those are their allegations. Guys, I'm fascinated by this Michael Avenatti case. I mean, the fall from grace, the guy was at a certain point in time, he was going to run for president. The idea that he got his fame really from the Stormy Daniels case, and now that Stormy Daniels case is going to whipsaw back. Imran, you've represented a lot of high-profile clients. He was already convicted in the Nike scam for trying to extort $25 million, of which he's still awaiting sentence. Now he's got this charge he's got to answer, and others, which we'll discuss in a moment. What are your thoughts about the Stormy Daniels trial, though?
Yeah, well, Bob, Michael. I mean, I think you hit the nail on the head. I mean, it was a meteoric rise for this attorney. I mean, out of nowhere, we in the legal world and also the general public suddenly heard the name Michael Avenatti all over the place. And I think, as attorneys, we're like, all right, this guy's going to be probably the next big thing. His name's all out there. He's representing some high-profile clients in high-profile cases. He's taken on the president, and we thought he was going to be a next up-and-comer, if you will, of attorney greats, right? Or at least names of attorneys who the general public could recall off the top of their head. But what happened with the meteoric rise? It seems like he's had a meteoric fall, and it seems to be one legal issue after the other for Michael Avenatti. He's out home under home arrest because of COVID, but he was in jail, and now he's facing more charges with this quote-unquote embezzlement or fraud of Stormy Daniels' money. And, as an attorney, you never want to touch your client's money. That's a sacred thing. You never commingle funds. You never dip into that. That is something ethically that we as attorneys really need to abide by. So the idea that Michael Avenatti allegedly bought Ferraris, took care of his dry cleaning bills with his client's money, that's really problematic on so many levels. Michael Avenatti is fascinating. Meteoric rise and meteoric fall, it seems. But I guess we're going to see how all these cases work their way through the justice system.
Yeah, Gigi, I always say if you get a client that's got so many cases and so many prosecutors and prosecutors' offices coming at you, how many bullets can you dodge? You already didn't dodge one. I guess you go to trial with it because you really can't lose. You've already lost one case and are facing a significant sentence. But from having a dad who is a lawyer, like I have a dad that's a lawyer, they drill into your head, and I'm sure your dad did too, to Imran's point, the two things you never, ever, ever do, because you'll get your ticket punched in a second, that means your law license, and be charged, is embezzle client funds, take client funds, and secondly, lie under oath. What are your thoughts with all those years of experience of working with your father as a paralegal in the office and now as a lawyer yourself about, Michael Avenatti knows this. He's not dumb. Is he just mentally ill to do something like this, or is it just pure greed?
I think Michael Avenatti flew too close to the sun. Just like you said, he's committed the very worst crimes that a lawyer can commit. Stealing money from his clients, lying. This is just very awful. And like Imran said, it's even more catastrophic when you consider how he was coming up. He was, Michael Avenatti, when he first came to the spotlight, was the advocate. He was the man taking on the big and the powerful on the behalf of those who can't advocate for himself. And here he is stealing from the very people that he promised to protect against these against these strong figures. And I think it's absolutely awful, and it's definitely a lesson to all attorneys. Do not touch your client's money. Do not forge your client's signature. And Michael Avenatti is learning the very hard way what we all should have learned in our ethics class in law school.
Imran, he's not the only lawyer where something like this has happened. And it's interesting to me because some of them are excellent trial attorneys. They're amazing. I could think of some in my home state of New Jersey. And they do these stupid things and these acts of criminality and now spend a life behind bars. I mean, have you noticed this? Is this part of maybe what made them great lawyers, that they took chances, they were on the edge, and then yet in their personal life, they can't stop that same thing from happening and get themselves into trouble? What are your thoughts psychologically about what goes on here?
Yeah, Bob, that's actually a pretty fascinating take on things, because yes, some of the greatest trial attorneys, greatest litigators are the ones who really take risks, who go into court and they sort of toe that line, and they sometimes possibly cross the line, but it sometimes has resounding success for their clients, right? And they're risk takers. They're perhaps A-type personalities, but maybe they take on too much.Maybe there's some point, which is a breaking point or a tipping point, where the line of what's right and what's wrong gets blurred, and with a criminal defense attorney, where they somehow step in the shoes of their clientele. And I don't know if that's what's happened here. I don't know if that's if there could be maybe a deeper psychological study on trial attorneys, and the personality traits that usually those have. But we know that when Michael Avenatti, he saw some resounding success and publicity, and sometimes that is what really taints a good thing, and it goes to someone's head, and they start making poor decisions. And maybe that's what we have here.
Yeah, they make poor decisions, and then you get things like this. California officials announcing the charges against Avenatti for which he will be tried. Let's take a listen.
took steps designed to obstruct an IRS collection, hide his coffee company's income, and prevent the IRS from collecting on a series of tax liens and levies filed since 2017. Third, bank fraud, including the allegations in the original complaint that Mr. Avenatti received 3 loans from a Mississippi bank based on applications supported by phony tax returns. And fourth, bankruptcy fraud. The indictment alleges that after his law firm was forced into bankruptcy over 2 years ago, Mr. Avenatti has repeatedly lied to the bankruptcy court, to the bankruptcy trustee, and to his creditors by failing to report income his bankrupt firm was receiving. These 4 areas of criminal conduct alleged in the indictment are all linked to one another because money generated from one set of crimes was used to further other crimes, typically in the form of payments designed to string along victims so as to prevent Mr. Avenatti's financial house of cards from collapsing.
Imran, I'm going to go to you first. When you're talking about these kind of charges, especially by federal officials, you're listening to them detail them. A lot of these are what we call paper cases. These are not very difficult to argue, and they never bring these cases forward unless they have an ample amount of evidence. Let me add, they're never going to bring a case of this magnitude forward with somebody with the I wouldn't say popularity, with the notoriety of Michael Avenatti unless they believe they have all the goods. I'm betting in my mind, Imran, that this is going to be a very solid case for the prosecution. Talk to me about your thoughts on that and the penalties that he faces for these very significant charges.
Yeah, Bob, you and I know that when you have the feds involved, when it's a federal case and there are FBI agents who are really doing the investigation backed by the U.S. Attorney's Office, they are meticulous and they take their time, whereas on a state case, maybe you have a street crime and you have NYPD on the street and they make an arrest and it's a quick process. And of course, there may be some investigation, before maybe an arrest warrant is executed, but it's nowhere near as meticulous, often, not always, but often as meticulous as when it's a federal case, a financial case, and a white-collar crime. And essentially, this is a white-collar crime. And that's usually paper heavy, as you say. It's usually the paper's trackable, meaning there's bank accounts, there's transactions, there's payments, and there's corroborating evidence to support these charges. And I think that's what we have here. I think that the feds probably did a meticulous job in shoring up their case, and they have a strong case, and it may be ironclad. And in terms of a sentence, Michael Avenatti is already in the hole. He's already, serving a sentence. Now, these piled on top of that, I mean, we're looking at someone who may not get any sympathy from the court. I don't think he's going to get any sympathy from the court. I'm going to go as far as to say that. I don't know what sort of mitigating arguments his attorney is going to have in terms of mitigating a sentence. But I think a judge is going to look at this and going to look at Michael Avenatti as a fellow attorney, or now disbarred attorney, but someone who was a member of the bar, who was held to that certain code of ethics. And the judge is going to be like, no, not again. This is too far. And he's going to have the book thrown out.
Yeah, Gigi, to that point, he will be looked at as a person that should have known better, that did know better. How do you defend him here in this case? Do you try to make a deal and work all this out to try to get some sort of reduced sentence?
Deal. Yes, as Imran just said, this is a person with specialized knowledge who should know better. There are very few mitigating factors that are going to benefit Avenatti in this case. Maybe he's got some serious mental defects that caused him to do this. Maybe he suffered a mental breakdown from his rise to fame. Maybe, but I seriously doubt there are any facts in existence that are going to save Avenatti from a stiff sentencing here. So it would behoove him to consider making a deal with the feds, hopefully getting all of his sentences at the same amount of time, at the same time, so that he can serve the least amount of time. But if he doesn't take responsibility for these crimes, it's going to be he's going to have a really hard time at sentencing.
Yeah, my feeling is that there's just no way out for him. He is going to fight this. That's in his nature. People, hope springs eternal. He's going to think he's going to get a reversal on that Nike conviction. And he's just going to fight it through, because I don't think there's any amount of time that prosecutors would offer, especially with these ironclad cases and with the conviction behind them, which they already have in the basket. And like Imran is saying, he's in the hole already. That would be satisfactory to prosecutors at this point in time. So I'm betting that's going to go to trial too. Guys, listen, we're going to take a quick break. But on the other side of this, in Houston, Texas, a sergeant was killed, and the police are on the hunt, because when police officers are shot and killed, the police spring into action with every single resource and asset they have, both on a federal, state, and local level. Stick with us. We'll be right back.
As patrol officers were dispatched to a shooting in progress call to the northbound service road in the 7900 block of the North Freeway. Officers arrived and found a Kia Forte abandoned on a nearby Stubner airline, and a male with a gunshot wound inside a nearby hotel. Witnesses came forward and claimed that two Hispanic males had a confrontation with the male in the Kia Forte. Witnesses told officers the driver of the Kia and the driver of the Mercedes fired shots at each other. The witnesses claimed one of the Hispanic males fled the scene in a light blue Mercedes. The other male fled in a black Chevy truck, a black Chevrolet truck. It was determined the wounded male had walked to a nearby hotel at 7766 North Freeway, where he was pronounced deceased. Upon further investigation, sadly, as we all know now, that male was discovered to be Houston Police Department Sergeant Sean Rios.
Right, so Houston Police Sergeant Sean Rios expired, as the chief had indicated. The date of this incident was Monday, November 9, 2020. Robert Solis, 24 years of age, is the person that has been arrested. They are looking for that person in that black pickup truck, and you can call at Crime Stopper HOU 713-222 TIPS. That's 713-222 TIPS. Or you can go to tips at lawandcrime.com if you have any information with regard. Now, with regard to this other individual, they are calling him a person of, quote, extreme interest. And the chief indicated, and I quote, "We need this person in custody. We're coming for you. We're going to find you. You might as well turn yourself in." And from what I understand, we see those pictures that are on the screen, Imran. They have some pretty good photographs. Those are some of the most clean photographs that I've seen. Many times as prosecutors, we would be upset that we had such fuzzy and faded photographs. It is just a matter of time. What are your thoughts, my friend?
Yeah, I agree. It's like a band of brothers and sisters with the police department in any city, any town. And when one of them is taken out, and unfortunately, in this case, that's what happened. When one of them is killed in the line of duty or even off duty, as we see here, everyone rallies together. The police department will be, they're going to be on full alert. They're going to be looking for this individual. And you could really, although it's not a suspect, this is still a person of interest. You could read through the lines that once they have this individual and they perhaps shore up some more evidence, maybe get a statement, maybe just have an ID to shore up their case, this person may go from a person of interest to another suspect, because we know that there was multiple people who were involved in the altercation, which led to the unfortunate passing and death of this officer. And that Houston PD is going to be out in force looking for this individual. And when they get him, they're going to be investigating and seeing if there's charges that's going to fit.
Yeah, Gigi, I could just tell you, if this were a case that were coming across my desk as a prosecutor, I'd have my state and federal partners alongside of me. We would be pulling surveillance from everywhere. We would be looking for license plate readers. We would be looking for poll cameras and traffic light cameras and every kind of video that you can to track this vehicle down. They've got a great description of the vehicle. They've got a great picture of the individual. They're geospatially mapping where this person could be going. Typically speaking, most of these people are found in very close proximity to where the incident occurred. What are your thoughts about all this?
I think you hit the nail on the head. I think that the resources available to the state in terms of investigating this case is going to be used to its fullest capabilities. I think that they're going to use all of their resources to track down potential witnesses, to review every possible surveillance video that was in the area. And once they find these suspects, once they find the person of interest that they're looking for, they're going to execute warrants for their cell phones and whatever other devices that they had on them to track their whereabouts just before and during and after the incident. I think it's an absolute shame that this officer died, in this way. I hope that his family finds grace and peace throughout this awful tragedy. And I also hope that the state conducts a proper and thorough investigation into what happened to Sergeant Rios.
Yeah, Imran, to Gigi's point, they're going to get communication data warrants. There's no doubt in my mind. How about yours as to whether they have already secured search warrants for the phone of the individual who has already been arrested? And they're looking at all the call logs right now, and they're trying to match it to the vehicle. I think this is going to be like shooting a fish in a barrel finding this guy. In other words, very easy.
Yeah, if there is, in fact, a connection between the person who's already been charged and arrested with this individual, and they do have the warrants executed on the electronic devices, on the phone, and they're able to get the data, which then connects that individual with the person of extreme interest. Well, that's all the more, PC probable cause to go after that individual and perhaps make an arrest. And that's what, you can expect that from Houston PD. It's one of their own who's been unfortunately killed in this matter. And they're going to bring it in terms of what they're going to do investigation-wise, search warrants, in terms of electronics, the triangulation in terms of cell phone data, anything to really link these individuals with the crime that they would be charged with, and the unfortunate passing of this officer.
Gigi, I got to ask, like I always do, because we are the Law and Crime Network, there will be a defense lawyer that has to represent at least this one individual, possibly both. What is the strategic considerations as a defense lawyer that you get into with respect to how you handle a case like this?
Well, when you have multiple defendants, first of all, we have to figure out who's going to represent them. Are they all going to need a public defender? Only the public defender can only represent one defendant in this case. So the other defendants will be appointed private attorneys by the state. From there, it depends on what the evidence says. I'm pretty sure I read in an article that one of the suspects was arrested during a traffic stop without incident while he was in the passenger seat. I think that defendant would have a much better shot at securing a favorable verdict or deal versus the person who's actually responsible for shooting the officer. So going forward, it's the defense team and the defense strategies are going to depend a lot on what the evidence the state has against the defendants.
Excellent point, Gigi. Well, we got to switch gears a little bit. Yet again, another doctor, this one, Yavid Parvez, I believe his name is called, has now been convicted and faces 465 years in jail for fraud for committing unnecessary surgeries. The U.S. Attorney for the Eastern District of Virginia was quoted as saying that the doctor preyed upon his trusting patients and committed horrible crimes to feed his greed. He billed millions of dollars to private and governmental insurers, and he is now convicted. And by the way, in 1996, the defendant was sentenced by a federal judge to 5-year probation and more than $100,000 in fines after pleading guilty to tax fraud. Gigi, I see this often that some of these doctors get convicted. There's all these Medicare and insurance scams or whatever, and yet their license is not pulled or they're allowed to move to another state and continue to practice medicine. But we're seeing more and more of this insurance fraud, and prosecutors do not take this, lightly, number one, and judges don't either, because you have victims, you have actual victims who had unnecessary surgeries, including many women who had hysterectomies that they did not need, are the allegations and part of this conviction, as well as the insurance fraud piece. I'm expecting this guy's going to get hammered. Even if he faces 465 years in jail, he may not get that, but I think it's going to be really up there. He's an elderly man. He's not going to see the light of day again, as far as he's going to die in prison. What do you think?
So regardless of how many years that he spends in prison, because he's already a very older gentleman. To your 1995 point, I think that the government should have considered pulling his license at that point, depending on the parameters of tax fraud. Unfortunately, it's hard to foresee what a person is capable of. He was convicted in 1995 of tax fraud. Does that really lend a reasonable person to believe that he's capable of committing hysterectomies and other irreversible procedures against almost 200 victims? That's kind of a stretch. So it's hard to blame the government for not pulling his license, but we can definitely bet that they're going to pull his license now, and especially since he committed fraud against the people. He billed Medicare or other government health insurances over 100 in the millions, actually. Excuse me. That is a crime against society, and rest assured that Dr. Perez is definitely going to get the book thrown at him, especially for abusing the trust that his victims and his clients had, trusted with him.
Imran, I'm going to give you a two-part question. Are we dealing with another Michael Avenatti here? I mean, is this, again, these are people who know that this is dangerous. It is clear that they know that investigators look at it. It's a paper case. It's not hard to prove. You have a previous felony conviction for tax fraud. Are we looking at the same kind of mental imbalance or whatever you want to call it with regard to this, or it's just pure greed? And number two, Imran, I need you to put that defense attorney hat on and tell me what sympathetic, heart-wrenching defense argument are you making for this doctor? I know I'm putting you on the spot, brother, but I know you can do it.
Okay, part one. Bob, exactly. We're thinking alike here. I was thinking, we talked about Michael Avenatti before, and we were talking about attorney ethics. What are we talking about here? We're talking about what a violation of the Hippocratic Oath. I mean, this is an individual who is entrusted by his patients to do what's best for them health-wise, to guide them medically, to treat them. This is an absolute violation of the Hippocratic Oath. Let's put the law aside for a second and the fact that he's violated all these laws, but his Hippocratic Oath as a doctor, it's egregious. The allegations are egregious. And, let's talk about that personality trait that you're alluding to that we were talking about with Michael Avenatti. Well, yeah, what's the common element here? I think it's money, it's greed, and that. I mean, I can't think of any other reason or motive, if you will, for this doctor to do what he has done, to violate his patients, to yes, the financial crime and the fraud, but to actually take a scalpel and conduct irreversible surgeries on someone. That is just horrific. And all for what? So he could bill an insurance company and get some payment in. What's the common element here? It's money, and money corrupts. And sometimes that's what we see. And we see on this level, Bob, a real egregious violation of the law and also this individual's Hippocratic Oath as a doctor. Now, your second part, what am I going to do as a defense attorney for this guy? Well, listen, I got a tough job ahead of me. How do you counter these allegations, which are seemingly shored up and corroborated by a book of evidence and also real people who are going to come in and testify about the horrific surgeries that they may have endured for nothing? Well, what is the deal or what is the defense? It's going to the prosecution and working out a deal to somehow get this individual less time behind bars, because, if these allegations are what they are and they're provable, that if he went and fought this, the judge is going to throw the book at him. So it's really working on the deal. But even with that, I don't know if we're going to get any sympathy from the prosecutor here.
Yeah, and the defense lawyer is going to be in a real tough spot for all the reasons that you've both articulated to pass what we call the straight face test with the court when you're making a sentencing argument. I expect pain for the doctor, somewhat equal to, not anywhere equal to, but much greater than the pain he inflicted on his victims. Guys, what does a 1972 cold case murder, a trial, and a conviction when the defendant is dead have in common? We'll tell you right after this break. Coming out of Washington State in 1972, Jody Loomis was 20 years old. She was found shot to death, and the case remained unsolved for decades. And in 2008, a crime scene lab tech found some DNA on her boots and actually preserved that DNA. And as you guys know, the story's been going as we move on and on with regard to genealogy DNA. They ultimately, the detectives take that sample taken from 2008 and they make a DNA match, again, getting some DNA from the defendant on something that was discarded. I believe it was a cup. And they made a connection. They made the arrest. He was charged with first-degree premeditated murder. Here's the quirky twist, and I was just talking to my guest offline before he went on the show. We've had defendants that have died before trial, but this case went all the way through trial. The defendant elected not to take the stand. The jury was in the middle of deliberations, and the defendant apparently, it's still apparent right now, killed himself, so there was a suicide. And the judge said, no, we're not stopping this case. We're going forward with the verdict. So hours after the alleged suicide, the jurors return a guilty verdict. Gigi, let me go to you first here on this. First of all, great police work again, all the way back in 2008, a lab technician making the decision, let me get this and preserve it. It's now used years later in order to make that genealogy match. And when a defendant dies before trial, you can't prosecute them and the case is dismissed because they haven't had a trial. But here the trial was virtually complete, but for jury deliberations. And the defense was, I'm sure, trying to say it needs to stop right here because the defendant has a right to be here at all critical stages of the litigation, including sentencing. But the judge was having none of it. So what are your thoughts about all of that? And does this case go to sentencing?
Yeah, I'm really excited to find out if it goes to sentencing. This is a very interesting and rare issue. Just like you said, if a defendant dies prior to trial, the case will be dismissed because he has a right to be present during every stage of the trial process. But here, the defendant died, whether it was suicide or other means, that remains to be seen, but he dies while the jury is deliberating. I imagine that the judge is going to allow the verdict to stand, and maybe at the sentencing phase, if it even gets there, they'll give him credit time served or something to that effect, where the defense and the state agree to some sort of deal. But again, we go back to the issue where the defendant has the right to know what kind of deal is going to be struck, and he's not present at this time. I think it's very interesting. And to your point also, I think this is evidence of incredible investigation work and the tenacity of the police department to solve these cold cases. And genealogy sites are definitely the 2020 snitch of the year.
Yeah, Imran, I'm going back in my mind, and each state is different. We always recognize that here at the Law and Crime Network. But something in the back of my mind says, what happens when there's been a conviction, there's been a sentence, and somebody dies while it's on appeal? And I'm pretty confident, and I could be wrong, but what are your thoughts about the idea that if a defendant appeals a conviction and a sentence and they die, that a case gets dismissed in some circumstances? This hasn't even gone to appeal because it hasn't even been sentenced yet. Do you see any appellate argument being made here by the defense saying, listen, we're appealing this decision because this verdict should never have been taken. He did not exhaust all of his rights?
Yeah, I mean, I see that this could absolutely be something that could be done on appeal for symbolic purposes, because I think that the fact that the judge allowed deliberations to continue and for this case to go to verdict, I think it was primarily a symbolic act. It was allowing the family of this individual, the deceased, to get some closure because we had a crime that was committed decades ago, an investigation, a cold case, if you will, an investigation that was cold for a while, a hit on a DNA, and this individual was brought into court to answer the charges for this individual's death. I think the judge allowed it to go to deliberation, allowed it to go to verdict, largely on a symbolic for the family to get some closure. Now, whether the defense is going to take this on appeal, it remains to be seen if they're going to take that extra step. But it's fascinating to say the least.
Yeah, Gigi, I agree with Imran. If I were a judge, just real quick, if I were a judge, I would let it go to verdict, and I'd be like, be damned with the appeal. If they want to reverse that down the road, let them reverse it. But I'm giving this family their day in court to hear the words guilty. Thoughts?
Absolutely. That is an excellent point. You know, the family deserves closure. They've been waiting for this answer for decades, and, you know, to wait to this moment, and hours before they get that verdict, this
I,
man kills himself or dies. It's a shame. And I think that
I
the judge is
absolutely
making the right
agree.
choice letting it go through.
Absolutely agree, guys. You were awesome. Thank you very much. Stay tuned for our regularly scheduled program. My name's Bob Bianchi. I will be back Monday. Have a great weekend.